have the distinct honor and pleasure of being able to introduce our panel this morning. Greg Demske is the Chief Counsel to the Inspector General, U.S. Department of Health and Human Services. He leads the HH Office of Counsel to the Inspector General, which provides all legal services to the largest Inspector General office in the federal government. This includes legal advice on audits, investigations, inspections, and other activities of the HH Office of Inspector General. Dr. David C. Herman was Senior Staff Fellow in Ocular Immunology and Uveitis at the National Eye Institute, National Institutes of Health in Bethesda, Maryland. He received a Master of Science in Medical Management from the University of Texas, Dallas. Dr. Herman is currently President and Chief Executive Officer of Vidant Health, an integrated healthcare system with 9 hospitals and more than 70 clinics headquartered in Greenville, North Carolina. Gabe Imperato, our moderator, is the managing partner of Broad and Cassel's Fort Lauderdale office and co-chair of the firm's white-collar healthcare criminal and civil fraud and compliance practice. He practiced healthcare law in both the public and private sectors for 36 years and is board certified as a specialist in health law by the Florida Board. He is also certified in healthcare compliance by the Healthcare Compliance Association. Ryan Meade is an attorney and consultant in Chicago, Illinois, who focuses professional work on healthcare regulatory issues. He is a law professor at Loyola School of Law in Chicago. Ryan is a partner in the law firm of Meade and Roach, a managing director of Aegis Compliance and Ethics Center. Dan Roach, JD, oversees the legal and compliance functions for Optum 360. He was formerly Vice President, Compliance and Audit for Dignity Health, formerly known as Catholic Healthcare West. Prior to joining Dignity Health, Mr. Roach spent 40 years as an in-house counsel for Allina Health System in Minneapolis, Minnesota. Please join me in welcoming our panel.
Thank you, Debbie. As you know, our advertised topic for this morning is corporate governance, compliance, and liability. But at the last minute, management and staff has asked us to address a different topic. So we're going to talk about specialty pharmacy compliance under state and federal law and the impact of healthcare reform. So which one of you want to start off the conversation? That's an April Fool joke. More seriously, some of you probably are aware that this is not a new topic. Corporate governance, compliance, and liability is something that's really at the forefront of everything that you do each day. But it is a topic that has changed over time. It's a different dynamic in each organization, and it will change again, and it will take on many forms and challenges as we move through the cycles of compliance in each organization. We're fortunate, though, this morning to have a number of different perspectives on this topic, so we're hoping to have an informative discussion from our panelists. Why don't we start with the general question of what we might speak of or say when we talk about the role of a compliance officer. I think I'm going to turn to Dan first, because Dan has played many different roles, has viewed this issue from outside, inside, with a couple of different hats, and for many years. Why don't you give us your view on that, Dan?
Gabe, I'm going to start with a question, and many of you know what's coming, because I can't speak in front of a group of compliance officers without asking this question. How many of you are responsible for compliance in your organization? Okay.
No, you're not.
Put your hands down if you're a compliance officer. Okay. The reality is, my view is no organization can pay me enough to be responsible for compliance in the organization. And many of you have heard me ask that question before. and many of you are now programmed not to raise your hand when that question comes up. But if you take nothing else from what I have to say today, never raise your hand when someone asks you if you're responsible for compliance in the organization. Because when we're talking about the roles of the board, the roles of management, and the role of the compliance officer, it's the board and management who are responsible for compliance in an organization. It's your job as a compliance officer to help them understand what they need to do, to be a promoter within the organization for the program, to be continually revising and changing the program to keep it up to date, to keep it effective, and to be reporting to management on how well they're doing, and to be reporting to the board on how well it's doing and the organization is doing. But you're not responsible for compliance. Most of you are not paid enough money to do that.
Dr. Herman, how about you? You're the CEO of a health system. What do you see as the role of a compliance officer?
In our health system, John's role is really to make sure that we're aware of what's going on out there. And then what I want him to do is to work very, very closely with the people in the organization to help make that happen. I think it's very important that everyone within the compliance office and people across the organization understand that we're in the business of healthcare. And when Tim and Jenny talked about credibility, John has to have that dual role, or any compliance officer has to have that dual role of understanding what's going on in the industry, what regulations apply to us, but at the same time be that bridge between the compliance and operations. I find it very interesting that we call it compliance, whereas a physician, if I accused a patient of being non-compliant, they would say, compliance is not something you talk about with a patient. We want our patients to be adherent. So I would say some of the things that John and his team have to do is not to drive up compliance through our organization, but help us all to be adherent to the regulations that are out there, and for good reason, and at the same time put them in the framework of the health care that we have to provide every day.
Greg, you're in a unique position in providing government leadership on the issue of compliance. What has been your experience, and what is your view of the role of a compliance officer in an organization?
Well, from our perspective, when we started doing corporate integrity agreements 20 years ago, we have always required the appointment of a compliance officer, and that's direct from the federal sentencing guidelines and one of the 7 elements there. And we've looked to the compliance officer to be taking the lead on promoting compliance with the standards of federal health care programs, and really standing to some extent in the shoes of the government. We've looked to really have a multiplier effect we can't be in the OIG or in the government at every healthcare provider. We don't have the resources. It wouldn't be a good use of resources. But we look for the compliance officers to be within the organization a voice promoting compliance with the law and promoting an avenue to address problems when they arise in an appropriate way.
What about, Dan, what about reporting lines for a compliance officer? What's been your experience in the various roles that you've played?
It's been different for the past 16 years almost at Dignity Health. I reported to the board with a dotted line into management. I think that reporting to the CEO or to the board is the best practice standard, but other reporting relationships can work, and I think one of the challenges for compliance officers is to be effective wherever you report, but to advocate, I think, for a more effective reporting relationship and to advocate for the best practices.
Well, if you have direct reporting to the board of the organization, as a compliance officer, what do you expect from a board? Or maybe ideally, and what's been your experience?
Yeah, it's a great question. One of the things that I initially expected from boards when I got into compliance is that they would understand compliance, and I realized very quickly that that wasn't going to happen. It was my job to give them a basic understanding of compliance, but let's face it, compliance is not their most important responsibility. I've worked for healthcare organizations. Their most important responsibility is to deliver health care, to deliver high quality health care, and that's where they're going to focus a lot of their time and attention. They have another huge responsibility around the financial health of the organization. They're going to focus a lot of time and attention there. So my goal is to get them the information they need to understand what our risks are and to understand how well as an organization management is mitigating those risks so that they can focus with laser precision on those areas where we have significant risks, where the risks aren't being mitigated, but then devote most of their time to the other very important pieces of their role.
Ryan, how would you describe the board's function from compliance? What I guess from a black letter standpoint, what would we say is the board's role in compliance?
Well, I think you'd have to go back to ask basic questions. What is the board's role in the corporation, and what's the business? They are, in a sense, the corporation and run it, though they're not involved in the day-to-day management. They have a fiduciary duty to ensure that the corporation business is following the law. Mm-hmm. And they have to exercise that with due care and so forth. So it's, as I think we all know, there's a line of cases, not a lot, but a strong line of cases which show that the board must pay attention. Now, what we're seeing develop is in settlement agreements with DOJ, OIG, where the board is reorganizing to have compliance committees, if they don't already have them, to pass regular resolutions and to exercise that due diligence in a more directed way, sometimes required as a condition of settlement. So we're certainly seeing the board getting much more deeply involved in compliance and that oversight.
Well, Dr. Herman, what do you look to from your board? Or put another way, if you had a significant compliance issue in your organization that had a fairly significant financial impact, are you going to be accountable to your board for that? And what are the questions they're going to be asking?
Oh, most definitely. I think most boards have been on a journey already, and I think we can leverage this in compliance with healthcare, is that back in the mid-2000s, each one of our boards, I think, took the journey towards quality and safety. So that through that, they've learned what it takes to get a culture of quality and safety in an organization. And I think we can leverage a lot of that operations and a lot of that learning towards compliance. So our board knows that if they don't set the tone, if they don't hold management accountable, that it's not likely to get done. And what our board is doing is they leverage that experience that they've had with quality and safety and provide that feedback to us as leaders in the organization that says, let's not just prove that we're compliant and we're adherent to the law, but what are we developing as a culture that supports that? Messages from the board, messages from my office, messages from other leaders are relatively ineffective unless you've built that type of culture within the organization.
Does your board hold you accountable for compliance in a direct performance measure? Very much so, very much so. So there are very few things that a board can actually measure with a CEO other than the bottom line and how the organization is performing to care for the people that they're caring for. But there are specific things as far as compliance goes, and we keep our board very, very well informed as to what the trends are out there, what our organization challenges are, and what they can do to help get that message across the organization. Of course, deficiencies in compliance can often be reflected in the bottom line, too. They certainly can. And I think there's going to be a lot of pressure across many organizations regarding the bottom line with the new things that are happening in healthcare. And I think boards are going to have to be particularly diligent that the bottom line isn't being supported through shortcuts in compliance. Greg, I know you've looked at board activity, management activity over the course of many years and have addressed it in resolutions of cases. What have you seen, past, present, look going forward with this?
Well, when we started doing CIAs, we really didn't have a role for boards in the documents. But as we've evolved over time and seen what works and what doesn't work in CIAs, one of the things that we've looked to do is add some responsibilities for the boards. And this really started in the pharma area, where we were seeing companies sometimes for the second, sometimes for the third time, often cases involving hundreds of millions of dollars. And sometimes criminal conduct. And our feeling was that as much as management has to have a primary responsibility for compliance, the board of a publicly traded company or of a hospital or other type of entity needs to be engaged in compliance as well. So we've started to make the board members or the the board committee that's responsible for compliance do have a duty of reasonable inquiry into the operation of the compliance program and to pass a resolution where the people with that responsibility are actually signing with their name saying that they've looked into the program, they've seen that it is operating, and to the best of their knowledge, the entity is in compliance with federal health care program guidelines. We have, in a few cases, in addition, required the board to actually hire an independent expert on compliance so that they are hearing a voice other than from management and the compliance officer to help inform their inquiry into how the compliance program is running. And one of the examples of a case like that, you can see that in some of our big hospital chain cases and pharma cases, but also in the recent settlement that the Inspector General mentioned yesterday, the Halifax case involves that type of requirement on the board.
And Gabe, let me just follow up on Greg's comment. I think if you really want to help yourself as a compliance officer and you want to help your organization, getting an outside compliance professional on the board or on the compliance committee of the board or the audit and compliance committee of the board is really, really helpful, at least from my perspective. When we did this back in 1998 at Dignity Health, it made a world of difference in my ability to impact the organization. And I know that there are a dozen or more of your colleagues sitting among you today who serve on boards of small, medium, and large healthcare systems in precisely those roles. So I think that's a huge step forward and really something that we should continue to promote.
You know, Dan, you mentioned that sometimes you've had direct reporting to the board, sometimes to the CEO, and there's been other forms. From my observation, I more and more I think that our compliance professionals, our compliance officers, need to have a seat at the C-suite table. Yeah. Have you found where you're, say, reporting to the CEO as opposed to the board can be equally as effective, or is it necessary to have direct reporting to the board?
Personally, I've never reported to the CEO in the compliance officer role. It's always been to the board. But you have to have a great relationship with the CEO. You have to be in constant communication with the CEO. Quite frankly, if the CEO doesn't trust you, in my humble opinion, the board isn't going to trust you as well. So I think, again, regardless of where you report, you have to build those relationships. And it was mentioned earlier this morning by Jenny and Cam that building relationships is extraordinarily important. And in my view, that starts at the top with the CEO.
Greg, what's your view on reporting? I mean, I know in a number of CIAs you look to foster direct reporting to the board, but can it work other ways too? Or?
Well, from our perspective, when we enter into CIAs, we always require that the compliance officer have direct access to the board and periodic meetings and reports to the board. We think that that's crucial in a case that we're resolving. Now, we understand organizations are different, of different sizes and resources, and that can affect how it's set up and what the board's role is vis-a-vis the compliance officer. But from our perspective, if the entity is settling a fraud case with the government, we think that the board needs to be involved and engaged and has to have that direct communication with the compliance officer. And we likewise feel that a compliance officer needs to be separated from the legal function of the entity, and we have required companies to restructure to ensure that the compliance function is separate from the legal function.
Well, let's talk about that a little. I think the whole issue of the compliance officer's role and its relationship to the legal function to general counsel has been a topic of ongoing discussion. Take us through a little bit of the history of that and how the Inspector General's views have been reflected on that issue and generally, why you think that's so important.
Well, when we started doing CIAs, we did not have that requirement, and several of the first CIAs, we had companies that the compliance officer was also the general counsel, but we saw companies that set it up different ways. So we experienced and saw in our monitoring of those CIAs what we thought worked better or not as well. We had an issue in one prominent case where the person who was wearing both hats is the compliance officer and general counsel didn't provide information to us that we felt should have been provided about compliance problems at the entity, and later claimed that they were privileged, these audits that had been done that had identified problems. So we want to avoid any confusion on that front, and when there's compliance issues that are identified and are required to be reported to OIG, we want that to be, we want them to come into us and not have any issue of privilege. That's one issue, but I think the bigger issue that we've seen in our observation and monitoring CIAs and when we talk to compliance officers is that when the roles are separated, the compliance officer has more time with the board, with the CEO, they get more resources, and they operate more independently, and they are in a better position to promote compliance. So as we've seen that, we've changed, and now the CIAs require that separation, and we've set it in repeated guidance documents that we've sent out to the industry that we think that that's the best practice. Now we recognize a small physician practice is in a very different situation from a multinational corporation or even a hospital. So you have, an entity has to make a decision based on its own capacity and capabilities, but the general rule is that we think, from our perspective, it's better to have the roles separated.
You mentioned the issue of privilege. I want to sort of get into that a little bit. I mean, Dan, Ryan, can the compliance professional in an organization effectively address compliance problems, without the use of privilege, especially in today's environment where, the whistleblower threat is fairly significant? I mean, can we have effective compliance without using the privilege?
I think there's a question which is deeper than just privilege here, and that's interpreting the rules. Mm-hmm. So before we get to the question of giving legal advice and whether that is privileged and investigating issues and gathering facts, just the role of the compliance officer versus the general counsel or legal counsel is one that the industry is trying to ferret out in a complex regulatory environment. If you take an example of the 2 midnight rule, yes, which was involved in the legislation yesterday that delayed...
Actually, I had that question last night at midnight.
At midnight,
yes.
Okay. Perfect. Did it cross 2 midnights?
And as soon as I get off this panel, I got to find somebody to go look at it.
Well, according to CMS, if you started the question at 11:45 p.m. and it crossed midnight, it counts as one.
But it has to cross 2 midnights for you to get paid for it.
Okay. Yeah. And who has to sign the discharge?
Yeah, right. But yesterday, for example, in the legislation, take a look at it if you want, Section 111, it's called Extension of 2 Midnight Rule. What does that mean? If you read deeply into it, it doesn't delay the 2 Midnight Rule, as has been somewhat reported. It just prohibits the RACs from auditing until March 2015. Mm-hmm. But what is the organization going to do now? Is it interpreted as a delay? Do you have to follow the 2 Midnight Rule? What's the compliance officer's position on that? The compliance officer, even if they're a lawyer, is not likely in a position to give legal advice. Mm-hmm. So I think it's important, particularly in complex regulatory environments, to make sure that the relationships and the roles of compliance officer and legal counsel are clearly established. They might have different perspectives on risk or defense, and I think this probably goes to OIG's position on having equal voices at the table to look at risk in different ways.
Actually, that raises a question. Dan, I mean, do you think having a legal background is important to being a compliance officer?
I think,
or maybe even sometimes a detriment.
The answer to that question is yes. Okay, so being a lawyer has helped me a lot, I think, in my role as a compliance officer, but it has also hurt me. And one of the things that I learned very quickly is that despite all my legal training, and all of the things that I was supposed to learn in law school, I know very little about operating a hospital. I know very little about how nurses work. I knew even less about how doctors work, those kinds of things. And I say this, and it sometimes comes across as being facetious, but I'm serious about it. I feel like my principal role as a compliance officer, particularly as a lawyer compliance officer, is to hire people smarter than I am and listen to them. So I want people who have been nurses. I want people who have been doctors. I want people who have worked in physician offices, who really understand the operations, but who are also committed to compliance, to do the right thing, because they're very effective influencers. And those that have worked for me will know that I had a lot of brilliant ideas that could never have been implemented. And they were kind to me, and they helped me see, what wouldn't work and what would work, and change my point of view. But clearly, I think being a lawyer can be helpful, but I don't think you have to be a lawyer in order to be an effective compliance officer. There are a tremendous number of compliance officers out there who do a great job, who aren't lawyers, but they partner well with lawyers.
Well, right. I mean, even though you have a significant legal background, in your role as a compliance officer, when you have a legal question, I assume you didn't try to answer it yourself.
Not most of the time. So,
well, you shouldn't have.
Yeah, that's right. But most of the time, I would go to the lawyers, and I was fortunate to have great lawyer resources. Now, there are times as a compliance officer you have to push back, okay? I think we heard keep it simple, stupid this morning. My lawyers at Dignity Health, and they're all great people, managed to create about an 80-page physician financial arrangements policy. And it's a fabulous policy, but let's face it, most employees at Dignity Health aren't going to read the thing, so I have to figure out a way to take that policy and condense it down into simple directives and simple guidelines that people can follow. And I think that's sometimes the tension between being the lawyer and being the compliance officer, is lawyers want to be precise sometimes, and I want to be effective. And I had to change that hat as I changed roles.
Well, now, I know for a fact that you're now in a role where you're wearing both hats at the same time.
I am.
I think your office has said that's an untenable conflict.
And for me, that puts the CEO of an organization in a difficult spot, too. I want people around the table that are providing the advocacy for their particular position, their particular realm of responsibility. And when that's shared, it's almost like Harry Truman used to say about the two-handed economist. He just wants an economist with one hand, because the economist always says, then on the other hand. Yeah. I want clear direction from counsel, then clear recommendations from the compliance officer, and then we can start working together to figure something out.
And, well, is it an untenable conflict for you? And if it is, how would you deal with it?
Yeah,
or how would you recognize it, would be my question.
Yeah, that's a fair question. So a couple of things. Those of you who have known me for the more than 20 years that I've been in compliance have heard me say probably hundreds of times, I don't think you should wear both hats. I continue to believe that. When I took this job in a startup organization, I said to management and the CEO that I would do both jobs for a while, but eventually we're going to have to split them out as the organization grows. I continue to believe that's the right thing to do. Now, the good news is, from my perspective, in terms of the conflict and how I recognize that, is we are owned by two large, sophisticated healthcare organizations who have great compliance programs, who have great compliance officers, who have great legal departments, and both of those organizations are resources to me, and there'll also be checks on me to make sure that I don't miss something in terms of that conflict that I should miss. I will not wear both hats in the long term, but right now, in the short term, that's what they've asked me to do.
Yeah, once I had this question sort of put to me by a client, and the organization was such that really that person had to wear both hats. That certainly happens. And at the end of the day, I just viewed it as a sort of simple conflict management situation, and I kind of prepared a memo that said, well, if you identify a conflict in addressing a situation, you do have alternatives. You can bring in a third party to deal with it and manage the conflict. I think that's possible. But I've seen situations where if the compliance officer is sophisticated and the general counsel gets it, and they know how to work together, that the byproduct of that for the organization is effective compliance. Absolutely. And it isn't 1 + 1 = 2. It can be 1 + 1 = 5. I mean, have you seen that in your experience, Greg?
Yeah, well, we certainly see the legal shop, the general counsel, has a huge role in compliance, and there should be communication and interaction between those two offices and functions. And I think where we've seen entities succeed under corporate integrity agreements, we've seen really robust compliance, but with strong communication and cooperation with the legal side.
I think maybe in your future corporate integrity agreements, you might work in a provision that requires the general counsels of organizations to attend our compliance academies. Debbie would really appreciate that.
Speaking of conflict of interest.
Yeah. All right. How about do we think that the compliance officer's role is clearly defined presently in the industry, and do we think that we have people coming to the table who have the necessary qualifications to be a compliance officer now and in the future? Ryan, I know you spend a lot of time in the educational sector in this. What are we doing about that?
Well, although I think it's very clear, and the success of HCCA and the 2,600 people here shows that compliance is now a profession. And it's not going away. It's an established profession. What's next? I think what's next is to have compliance recognized as an academic discipline. Mm-hmm. We now have 15, 18, close to 2 decades, years studying what is the effect of a compliance program on the organization, where should it fit, what are best practices, what works, what doesn't work. There's no one right way, but we need to start studying this and also training. The conferences, the academies that you and I teach at, those are vital education components. But I think that the compliance as a profession has now reached a stage where we need to study it systematically and offer that opportunity. That's in my new role at Loyola as Director of Regulatory Compliance Studies. That's what we're doing with our on campus, but mostly online master's degree, where folks who can, they can't move and come to Chicago, and who would want to come to Chicago this year with 50 below wind chills? You'd want to rather stay in San Diego. But to try to learn and go more deeply, how do you do a compliance audit? Take a Stark intensive course so that you can get more than 90 minutes or 2 hours. This is where the profession needs to go, I think. And I think to Dan's point, you don't need to be a lawyer to be a compliance officer. But we do work in an area of intense regulation and law, and we have to have some understanding and some facility with reading those laws.
I mean, when I look at the sentencing guidelines for effective compliance, I mean, those are all pretty much operational type tasks. They're not legal functions.
No, right,
you know?
Right.
And I never thought that the compliance officer needed to have any different role with respect to legal advice than any other operational VP in an organization, you know, that dotted line. Right,
but it seems that there's both horizontal and vertical aspects of compliance programs. You've got the 7 elements from the sentencing guidelines and OIG's guidances, but then you have deep substantive regulatory environment that we live in, whether it's privacy, research, reimbursement, fraud, and abuse. And how do those interact and integrate with each other in the context of the 7 elements?
Well, so in your educational lineup, what kinds of things is that program sort of hitting on for the compliance officers? And this leads to a master's degree?
Yes, it's a master's degree for lawyers and non-lawyers, MJ or LLM. Well, studying compliance, I think, is important, just the 7 elements, fleshing it out. What I've been talking about is both in ethics, we have ethics, ethical theory, and applied ethics. I think we need to move to thinking about compliance and applied compliance. So we can study the 7 elements, we have to study those elements, but what do they look like on the ground? How do you take a stark non-compliance or something that's very close to non-compliance and turn it into a corrective action and effectively.
What, they're teaching that at this program?
Well, we try.
Greg, why don't we talk a little bit about what we've seen roll out in terms of organizational liability, over the past few years. I mean, when we talk about organizational liability, what are we talking about?
Well, first of all, there's a range of statutes that apply, certainly in the federal level, starting with the False Claims Act on the civil side, and then criminal statutes, administrative statutes that our office has for civil money penalties and exclusion, and then you've got all the state authorities in play. And really, what I think the government has tried a lot of different types of things to try to change organizational behavior in the context of investigations. Sometimes it's been through criminal prosecution, although, of course, an organization can't go to jail. It's different from an individual. And so we've tried to do things, corporate integrity agreements that apply both in criminal and civil context to change behavior. The Department of Justice has done cases where they do what they call a deferred prosecution agreement, where they believe a crime has been committed, but instead of going forward and prosecuting, they enter into an agreement. I mean, these are much more intensive usually than a CIA, where there can be a monitor that actually is directing some of the business operations of the entity. We've seen also the government has continued to try to find ways to hold individuals accountable in the context of resolutions of cases against corporations. And those cases are inherently more difficult to bring, particularly criminal cases. So I would say the government hasn't always been successful in our efforts to do that, but there have been, in this last year, there was a case down in Florida, the WellCare case, where the former CEO, CFO, and 2 vice presidents were convicted on healthcare fraud and related offenses, where the company had previously settled with the government. That's an example of where the government has been successful at holding decision makers and executives responsible and accountable for criminal conduct.
Why has that become important? Because we've seen it more and more in recent enforcement policy and actions. I mean, why has it become important?
Well, I think that we in the government struggle with the issue of how do we change behavior? I mean, from the OIG's perspective, we want to see enforcement, we want to get money back for the government, but we really are most focused on trying to protect our programs, the Medicare, Medicaid programs, and the other programs of HHS going forward. And how do we do that? And we think that perhaps CIAs are very important in changing and putting in a culture and processes and controls at an entity, and the work that the people in this room do is irreplaceable as far as changing conduct at a corporate level. We also think sometimes for individuals in positions of responsibility, it's helpful for them to know that there could be consequences and accountability if they engage in fraudulent conduct or even are responsible for a business unit where fraud has occurred. So we're trying to find better ways to do that, both criminally, civilly, and as well as administratively.
Yeah, I guess if an organization has some compliance deficiencies, somebody somewhere in the organization has to be responsible on some level, right?
Right.
So.
And particularly where we've got criminal conduct, the government wants to hold individuals accountable in addition to just collecting money back.
Let me go back to something that you mentioned and preface it with, I think we all know that our government payers who pay substantially for health care, and that's even more so on the horizon with health care reform, expect organizations to partner with the payers in detecting and preventing non-compliant conduct. And in my experience, I work with many organizations to respond to reports of noncompliance, to investigate it, detect it, corrective action, and or make a disclosure of the situation. But we've had situations where we're legitimately and in good faith in the process of doing that and creating whistleblowers as we're doing it. And the organizations feel, at great risk even while they're taking remedial action. So, the concept of privilege is important, but at the same time, the organization doesn't want to limit its responsibilities to the payers to partner in detecting, preventing. What recommendations do you have for organizations when they come to you and, you know, they have done a privilege investigation, but, you know, you need to know the facts, transparency, but on the other hand, you know, there's a desire not to undermine the privilege and its usefulness for effective compliance. What recommendations do you have for us in you know, dealing with that dynamic?
Well, certainly in our self-disclosure protocol, we're very clear about the fact that we don't require anyone who's disclosing to waive privilege, but on the other hand, we need to have the information about what happened, the facts. We are not interested at all in the legal advice that was given to an entity. What we want to know is what happened, and we need to have that to decide how to resolve the case appropriately. And the fact is, we have done hundreds and hundreds of self-disclosures. It really hasn't been an issue. We have never asked anyone to waive privilege to get the information that we've needed to resolve the case. And we have, I think, a very good track record of handling those cases and resolving them fairly quickly compared to the opposite situation that we see in a Ketam's relator case, where the entity has much less control. The process often takes years and costs a lot of money and a lot of disruption. Two primary examples from the last year would be Halifax and then the Toomey case, which is still not resolved, but there's a verdict of over $200 million against the hospital. In both of those cases, you could see there were people either within the hospital or a physician at the hospital that raised concerns that the hospital didn't really address appropriately. And instead of identifying the problem, ending it, and coming to the government, they lost control of that process.
And was that one of the primary reasons why your office felt like a corporate integrity agreement would be necessary for resolution?
Yes. I mean, first of all, to have an $85 million settlement with a single hospital, that's a lot of money. And that's one of the factors that we look at with respect to whether we are going to require a CIA, but also the breakdown of the basic, the substance of a compliance program. However it looks on paper, if you've got somebody from within the hospital who's raising a concern that's legitimate, a true compliance culture would find an avenue to deal with that internally, and that didn't happen there.
Dan, have you ever ignored a report of non-compliance on a hotline or otherwise?
The question is, yeah. The answer to that is no, not a serious call to the hotline. I don't think I've ever ignored. You know, we do have, and we were talking about this earlier this morning, not every call to the hotline is created equal. I've had people call complaining about the views from their offices. For the most part, I have ignored those kinds of calls. But if someone is raising a substantive...
But you know the difference between the two, right?
Absolutely. But, you know, you shouldn't ignore calls that are serious. And quite frankly, it's one of the quickest ways for the organization to get in trouble, because eventually the government will find out. One of the things that has been said over and over by people a lot smarter than I am is that you can't hide stuff very long. It will come out. And, you know, we're better off being transparent, in my view, following up and fixing the problems.
Yeah, I know from my experience that at our academy presentations, I don't have any hesitation saying at least two things. You ignore a report of non-compliance at fairly significant risk to the organization, yep, and you live in a fishbowl.
Yep.
That's just the state of... What do we see when we talk about compliance now that we have major health care reform, and what are some of the things on the horizon that you're expecting to deal with even more directly or more immediately?
Well, I think from the OIG's perspective, a couple of things with respect to the Affordable Care Act. One is the expansion of Medicaid and the much greater federal stake in Medicaid. So for those states that are expanding Medicaid, 100% of the spending for those newly eligible beneficiaries is going to be federal government spending. So that really changes the equation. That's for the first few years, and then it goes down to 90%. But it really changes the equation for us, because we have traditionally looked to the states to be on the front line of protecting the integrity of the Medicaid program. So that's one thing we have to really be focused on. We have to look at how the states are doing, but also directly look at more Medicaid. And then the second thing would be in the some of the payment changes in the Medicare system under ACOs and the whole direction that we're going through paying more for quality and outcomes rather than volume of services is the validity of the information that we're receiving on clinical outcomes that affect payment. And I think that's a new compliance risk area that we'll be looking at. And then in addition, finally, just more money, federal money at stake.
Yeah, I don't really see the state resources for enforcement are limited. I certainly don't see the states exercising compliance leadership like the Office of Inspector General has done over the years. It's going to be interesting. Why don't you talk a little bit about the things that your office tries to do to take a leadership position on compliance? Because I think of all the government agencies, the Office of Inspector General of HHS really has taken on this role the most effectively. But what are the kinds of things that, when you wake up in the morning, these are things we're going to do repeatedly or try to do?
Well, first of all, historically, you can go back 25 years to when Congress gave us the responsibility of issuing safe harbor regulations under the kickback statute. And we did those regulations, but at the same time, we came up with a fraud alert that we would issue to the public about joint ventures. So we were identifying what you could do to comply with the law, as we were required to do by Congress, but we're also identifying problematic conduct. And so over time, when we started doing CIAs, we put all those on our website, and then we put out compliance guidance for anyone who wasn't under a CIA to know what we thought were risk areas and what we thought were best practices to promote compliance. And we've continued to do that through different forums, and we've done in-person training. We've got videos on our website on a variety of topics, trying to both talk about best practices but also risk areas. And that really comes from a realization that we have a responsibility, as I said, to try to protect the integrity and economy and efficiency of the federal health care programs, and we can't do that. Every employee in OIG, if you look at all the auditors and investigators and lawyers, we're responsible per person for over $500 million of federal spending. We can't really monitor that by ourselves, so we have been able to and promoted voluntary compliance, and it's a credit to the industry that we've got the Healthcare Compliance Association is such a large organization. You are out there on the front lines doing work that really benefits all the government and all the taxpayers in the federal healthcare program. So we remain committed to that, doing what we can to promote voluntary compliance and give information to the industry, as well as our enforcement and auditing and evaluation rules.
Well, we're almost out of time. I guess I want to ask you, Dr. Herman, so does this make you want to go back to Vidant Healthcare and make a request of the board for expanded resources for your compliance department? Well, or do you want to ask John Falsitano not to retire and to stay on for another?
Our challenge is going to be, with all the changes in regulation, building those into operations. When I hear what he's been saying, it's about behavior, it's about conduct, and it's about culture. We can't brute force everything. Yeah. What we're in an era right now is we're getting the regulations or something's happening, and it's just another sticky note on the computer screen that tells us to do something different. We really have to build it into the culture and really have to build it into the operations. We have to make sure that the right thing to do is the easy thing to do. And so we'll be working with John, and whatever resources he needs, he'll get, but he and I sit down and decide what he needs.
There you go, John.
Then we work it from there. But we're committed to building the same culture of accountability for compliance that we are for quality and safety in our organization. That's how we'll continue to take great care of patients now and in the future.
I think that's a wrap. We're out of time. Thanks very much for your attention.